Okay, well, we're going to start over again, and I think we've reached the point now where we can go into the Bill of Rights. And first of all, let's kind of see if we can go over this and see we got what we call the preamble to the Bill of Rights. Now this is a little self-explanatory, and I'll read it for you. Articles in addition to an amendment of the Constitution of the United States of America proposed by Congress and ratified by the legislatures of the several states pursuant to the 5th article of the original Constitution. All right? Let's see now. Let that kind of see what they're saying, just common everyday language. Let it sink in for a minute, we'll come back to it. Now, the preamble, just as the preamble to the original Constitution, is an introduction, which actually tells you what is to come forward. We can also go to a Supreme Court case, will also explain to you that the preamble to this is the preamble to all amendments. All of the amendments that comes later. This is that preamble. This is not, remember, always remember that amendments to the Constitution are really more delegated. They have to go by their delegated authorities. Now, those delegated authorities is not delegated or not delegations of surrender. So therefore, this is what we're going to do at the convention. After the convention of a number of states having at the time of their adoption of the Constitution expressed a desire in order to prevent misconstruction, abuse of its powers, what? That further, meaning more. The original Constitution has put what restrictions and clarifications here. Now we're going to put further declaratory and restrictive clauses should be added and extended. The ground of public confidence in the government will best ensure the benefit ends of its institutions. What are all of that in common grounds? What are we saying? Now, first of all, we know what brought this about. What brought this about? Why did we need a Bill of Rights? We spent all the summer here going through and building this, what we call a new Constitution. Why did we need this Bill of Rights? Because there were some people who were upset about it. And they were like the radical group that they call patriot hardships, like Patrick Henry and George Mason, both of Virginia, the largest state at that time. They saw some things in the Constitution that they didn't like. They thought that if we believe that all men are good men, it's fine. But we need to put further restriction because there may be something on good men. Now we say, and then there were people like Hamilton who made the statement like this about against the Bill of Rights. Now listen to what he says very carefully. And what he said is absolutely true. He said, why should it be said that the rights of the people, no, I'm sorry, that for why declare that things shall be done when there is no power to do it? Do you see what he's saying? Hamilton is saying, why should we need a Bill of Rights telling the government what it can't do when it never was given that power to do it? So even when they added the Bill of Rights, but they had to do something with George Mason, especially from Virginia, powerful man, and he got together with the president at that time, George Washington, and said they would adopt this Constitution provided this declaration was added to it. Now watch this. The declaration was added to it. It couldn't be added to it at this late date. We first have to approve it, and then I'll guarantee you, when I open up with the next Congress, I'll present this Bill of Rights. Okay, George Mason? Yes. Then he and Patrick Henry decided that they would then ratify the Constitution. What is this Bill of Rights that we talk about? What is a Bill of Rights? Let's see. It is something that the legislatures make. When the legislators make something, they are promising that I'm going to get in your business. That's all they're saying, and that's what they're trying to say there. The title of Bill of Rights. It's a legislative promise to limit their own powers in places where this Constitution grants unlimited powers. And usually in unlimited powers is found in Article 1, Section 17. Now, there was one other section about this Bill of Rights that I want you to see. The Bill of Rights, the amendments were for the freedom No, here it is. This is from Bouvier's Law Dictionary, from page 362. It says, all amendments of the federal Constitution are under the same title. In other words, he's saying that all amendments that come hereafter are under the same title because they were supposed to be further restrictions. What does that say? What is that actually saying? That means we are saying to the federal government that this further declaratory means we are here further explanation or explaining it to make it clear and restriction other things that you leave alone. This is for the government. The Bill of Rights was written for the government to take any restrictions, all restrictions that they're saying that this is what we're not going to do or become involved in. That's what the Bill of Rights was. We are not going to become involved in this. This is their promise to you. Now what you're going to see, how did they combat all of these things that they promised? And we have all the literature that tells you that they promised not to bother you with these articles or these amendments to the Constitution. What changed it? And you see, Gene, that's the 14th Amendment. They changed this, the 14th Amendment, changed the restrictions on Congress, and they made them restrictions on the states. And we'll go through that gradually. So if we can, maybe we'll start and read with you the beginning of these amendments. Now, let me just see if I can, because I forget some of the things I have to say to you earlier. Let's see what these things are. Remember what we said earlier. They are going to be what? Remember, always remember. They're going to be declaratory clauses, or they're going to be restrictive, further restrictions. I'm going to make it clear, or I'm going to put further restrictions on Congress, legislative acts. Now, all I'm saying to you when I say that all of these are either going to be restrictions or making something clear in this Constitution. That's all they're going to do. When they start doing other things, they're going contrary to what was meant by the amendment process. Here you will notice the first one off, it says, Article 1, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. are the right of the people peacefully to assemble and to petition the government for redress of grievances. That's pretty clear. But most people have changed it so that it's not so clear. This is very clear. You can't interfere in religion. There's no place in here in this Constitution that talks about the separation of church and state. That can only be found, I think, in Article 1 of the Soviet Union Constitution. Separation of church and state. Not here, no such animal. In other words, we can prove to you that this is a Christian nation. They don't want you to say that anymore. This is a Christian nation, but all religions was welcome. This is what they're talking about. But this was actually a Christian nation, and it still is. But they turn around because of a later amendment, and they are using this as restrictions upon the state. And so now you can't have these nativity scenes and this sort of thing. They've changed all of these. That's the only way they can get into your business. But we'll maybe come back to that. Let's go to Article 2. Now remember also, there were hundreds of amendments added. Hundreds of them presented to Congress. Hundreds of them. And finally, I think the last 20 was brought up to Congress. It was whittled down to that. Something like that number. But they decided to take from, I think it was 13, and they took from 10 down or 9 down, whatever. 1 and 2, they left off and just took these. Now remember, I want y'all to help me remember this because I don't want to forget before I'm through. I am talking about each one of these, we're going to talk about restrictions. And then we're going to see in between, there were no restrictions, there were just changes because of the stupidity of the American people. I say stupidity on all of our parts. Now, but what I'm trying to say, and please help me to remember because I know I won't. You're going to see that these are restrictions or either making something clear. All of the others is not until you come to number 27. The recent one. You remember? You don't remember, but you find it in your book and you remember. And it's going to look just like these. It wasn't added to the Constitution. It was presented here. And wasn't added to the Constitution in 1992. About not raising their salaries. Look at it, number 27. And it'll say no. When you say no here, I know this comes under what? A restriction. We said we're talking about restriction and make it clear. The restriction here, that's an R, I would say. Now here, we said, and we're going to have someone come up and talk about this at length, a well-regulated militia being necessary to the security of a free state. The right of the people to keep it their arms shall not be infringed. Not be infringed, not be violated or entered into. So I'll just leave that there until Mr. Carter is going to come up and do that. Go over that one with us. Number 2, is that right? Okay. Now let's look at number 3. This is declarable, isn't it? This one here start off with no. So that's something we're prohibited in Congress to do. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. That's pretty well explanatory. Now then, let's see what Article 4. The right of the people to be secured in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated. Not be violated, and no warrant shall be issued but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the person or thing to be seized. That seems very clear, even though they are toying with that now. All of these things they could not touch prior to some other amendments to do that. And it appears that it was an intentional act. we'll go back over those if there would be some that you want to. I'm going to go over the first 10, and then maybe we'll have someone come up and explain the others. Now, watch this. Here we are. We got another restriction. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Pretty self-explanatory. Except in cases arising in the land or naval forces or in the militia when actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. That has said a lot. This is a restricted, unrestricted clause telling the Congress and the government what it cannot do. They talk about, they don't ask for these crimes. Who's responsible for these crimes when they're in the armed forces? Arising of the land and naval force or in the militia. This we would see in the original Constitution is talking about this is the authority of those courts that we talked about. Now here we're going to go into criminal prosecution. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. Some have had trouble with that over the years. To be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistant of counsel for his defense. Assistant of counsel. I know many patriotic groups have had problems with that. Now then, we're going to go to Article number 7. Always remember, even though I forget to mention it, that either these are going to specifically state that there are restrictions, or it's going to just simply make a statement which clarifies what they cannot do. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. We are talking about one thing here. We're talking about common law. I want you to watch this when it says the right of trial by jury. Whenever you see the word by, it's going to be talking about that which follow is the agent to do something. So you can, if this had been trial by judge, that would have never been a problem for most of us. Because when he says trial by judge, he certainly doesn't let the jury come involved. And the cases will show you trial by jury meant just that the jury were supposedly the people to judge. Your peers were supposed to judge you. Let me give you an example that someone mentioned to me just the other day. If, this probably doesn't make any sense, but I'm going to try. supposing that I go into your store, I rob the store, the clerk is there, I rob the store, and then I'm finally caught and go to trial. The clerk then points me out. I go before the judge, and the person who's sitting as the judge is the other clerk of the same store. Has anybody ever said to you, and maybe I'm far out, if I have a prosecutor and a judge getting that check from the same place, is or is that not a conflict of interest? How can you be impartial? How can I take you here, a clerk of the store, or the owner of the store, and the clerk, he's sitting here, that's like somebody stole a chicken, and right here sitting on the bench is the fox. So why hasn't somebody brought that up? Or is it some type of close cohesiveness that they just don't talk about? How is that possible? That's why it was trial by jury. That's why in the first Supreme Court case, I think it was Georgia versus Beresford, where the first Supreme Court Justice John Jay said that the jury has the right to judge both law and fact. Because that's the only thing you got left. That's the only thing that you got left to say. Any law that's bad, you can rule on it that's bad. But for some reason, we've gotten away from that. We have not kept up with our learning skills. That's what we're here for. So now, let's go to the next one, Article 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel or abusive punishment inflicted. That's self-explanatory. Here are the ones that we talk about a lot. The 9 and 10. Let's go to 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. All of these rights that were listed in the Constitution, the written Constitution, all those rights shall not be interpreted to deny or disparage others retained by the people. Everything they said, only thing that you have to work with is the one that's listed in the Constitution. Everything else, leave the people alone. That's exactly what they're saying there. The final one, they said, the powers, follow this up, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to people. Now, is that so hard to understand? Is that so hard to understand? It says that the powers that are not delegated in this Constitution are reserved to the states, or after the states who made this contract with this new government, or to the people who are the kings and queens. With that we got the first articles. Now we're going to see if we have the Bill of Rights. See if we can have, at this time we complete the Bill of Rights. See, maybe I can ask if there might be some questions. If there are any questions, sure. Come on.
Article 9 about certain rights not being enumerated in the Constitution. I've heard a lot of this about the freedom of travel.
Okay.
It seem like that would cover the freedom of travel?
Let me see if I can. I know what you're saying, and I know what you're saying is correct. But let me say it as succinctly as I can. That listen, anything that's not listed in this Constitution, you have the freedom to do. Remember, you had freedom prior to the Constitution. This Constitution wasn't written for you. This Constitution you wrote for them. These are the rules that they have to go by, not you. You only employ these people here to protect all of the state's rights, to secure your rights. You only relinquish a few rights for the protection of the whole. So, remember, and I always say, these streets belong to you. You see, before the 14th Amendment, there were no licenses for you to marry, to drive a car. So now what happened? You went and traded in your sovereign rights for privileges. That's a sad commentary. That's why I always say the problem is going to have to be addressed by those who have been hurt most. You traded in your right to drive for a license, for a permit. They began having, listen, before slavery, all the slaves, if they were making a notation, would be in the Bible and everybody else. Then when slavery became under the purview of the people, of the government, they began having them to everything they did, they have to get a license. See? That's the saddest thing. And we're going to touch on that in a little bit. But as far as driving, there was the only certificate for driving was meant for to see if you were competent. So that, to me, I don't see where driving or anything, there is nothing in this Constitution that said they had any jurisdiction. And jurisdiction is the power to act. So no, they didn't have it. I don't think. Any other questions? Come on, Walt.
On 4, on a speedy trial, it said the last there, it didn't say anything about an attorney. It said it, somebody to represent you. Now, could that be construed to mean need an attorney, or under the common law, yourself being represented by yourself?
Well, let me tell you how I interpret that. You first, let me just give you a drawn out piece. First, you know we had the Articles of the Federation. When we met in the Articles of the Federation, we were meeting to strengthen the Articles of the Federation, not to write a new Constitution. In that Articles of the Federation, the only way we could build this Constitution was take out the things we wanted in the Articles and build on the things that we wanted to strengthen them with. In the Articles of the Federation, it says you had a right to come to court with your agent. Nowhere does it say anything about a licensed lawyer.
Right.
No place.
No place.
No place in the Constitution, no place. That came in years later under the International Bar Association. But no place does it say that. Now,
Well, it's a judge's right to uphold the Constitution. So if it's the judge's right to uphold the Constitution, then they can't bar you from the court by a representation.
you know, I always say to my good friend Gene, and he talks to me a lot, like he's awfully upset about it, but I've always said to him, I understand the frustration. I've had them the first 3 years I started, and it can be frustrating. But if not the people, who do you turn to? You're not going to go up here and expect that which is right for you. Then you take, when I've taken advantage of you, if I had the heart to take advantage of you, what makes you think I'm going to just, I'll give it back? Until the people learn what has actually happened to them, you will never, never, never in the day of the life. But now, I had a friend, not a friend, a gentleman that I knew some years ago. You know what he would do? He would make, and I think I have a copy of it at home, he would draw up what is called a power of attorney. And he would give his friend all of the things that an attorney is supposed to do for him. And he would send that to the judge. Now, how can you be the power of attorney? But that's a good question. And hasn't been resolved. I think most of us know what's really supposed to be, but it hasn't been resolved in the courts. And one day it will, because I think people have become more involved and more educated about what's right. But it does not speak anything about an attorney at all. It says an agent of the law. And that's a good question. But let me say one other thing about the Articles of Confederation along that line. You see, in the original Constitution, it mentioned a point by establishing tribunals. In the Articles of Confederation, when you look under Article 9 of the Article of Confederation, what does that, it says constitute, in this constitute tribunals. What does that constitute? It means to set up. Now, watch this. In that Article of Confederation, what does it say? It says this. It says when you have a trial or something of that confusion, then the Congress will pick people and make them commissioners to judge this particular case. It didn't mean you have a court here and yonder. It meant just ordinary people. Ordinary people. Read that. Get a copy of your Articles of Confederation. Read 9, and you'll see mine. That it didn't mean what they have us doing now. That they are setting up courts. It meant when something came forward, we would set up a court back door. 3 people here, and might say, you resolve it. That's it. But not all over panel. Okay. Are there any other questions? Now, where? All right. So, are there any? At this point, let me just look at some notes here about these articles, so I don't want to miss on any of them. The Bill of Rights. That was George Mason. The Bill of Rights for further restriction. I mentioned that. The Bill of Rights was not imposed upon the states. Oh, I'm getting a little about the states by the 14th Amendment. The 14th Amendment gave no benefit to white citizens. This is in the case of Bates versus Illinois. And the further amendments that we're going to get into later, that we're going to talk about that, those amendments for the African race. Okay. The Bill of Rights is a legislative promise, I think we've gone through that, to limit their own powers. We've gone through that. And Patrick Henry, this is what I was trying to say that Patrick Henry had said. He said, when evil men take office, the whole gang will be in collusion. They will keep the people in utter ignorance and steal their liberties, unquote. Now, and also I got a note here about what authority do they violate the preamble of the Bill of Rights, which has forbidden them at all times from engaging in the field of firearms. Okay. Now finally, in no case whatsoever that's a restriction on the Bill of Rights. You'll find that in WAIZ versus Tax Corporation 397 U.S. 701, and restrictions on the Bill of Rights. Now we also find in the Federal Papers number 84 in regards to the Bill of Rights, and this is what Hamilton said at that time. Quote, he says, "They have no application to the Constitution professedly found on the powers of the people and executed by their representative and servants. Here in strictness, the people surrender nothing," unquote. That's what he's saying about those almighty Bill of Rights. The power to amend is certainly not a power to destroy. They are only legislative enactments. Now, with that, we're gonna talk. You have a question?
Well, what about on that 7, Doc? Talking about the jury in it, in the common law?
The jury.
Yeah. Now, see, the jury also has the power to, not only judge the law, but judge the guilt and innocence. Is that correct?
The judge what now?
The guilt and innocence, but also to judge the law if it's a bad law.
That's right.
Constitutional law.
Well, that's absolutely right. They have that right to do that. But you're not told that.
So the jury has the right to judge both the law as well as the fact in controversy. The Supreme Court,
Read.
1789.
Okay. Who's the Supreme Court? John Jay?
John
What was
Jay.
that? What was the name of that case?
Just
Bruswell versus Georgia versus, what's the name of that case?
They doesn't say, it just says that, it just makes a statement.
Yeah, well, that's right. That's the first case. That was when, the only case that the jury went before the Supreme Court.
Oh, okay.
Yeah, that was the first and the only time that he had a jury there. And that's when he gave them that mandate,
Okay.
what they could do. Yeah, it was Georgia versus Brailsford. And let's see, what did he say? The charge of the jury in the first jury trial before the Supreme Court of the United States illustrates the true power of the jury. In the February term of 1794, the Supreme Court conducted a jury trial in the case of State of Georgia versus Brailsford. It is presumed that the juries are best judges of facts. It is, on the other hand, presumed that the courts are the best judges of law. But still, both objects are within the power of decisions. You have a right to take upon yourself to judge both and to determine the law as well as the fact in controversy. That's signed by John Jay. Also another case, the United States versus Doherty. And it points out, as the United States Court of Appeal pointed out, when that was in the District of Columbia, unreversible and unreversible power to acquit, disregarding the instruction on the law given by the trial judge is in the jury's hand. So those are some of the cases that verify.
If it's a bad law, you can just throw the whole thing out.
That's the only protection that you have.
Yeah.
The jury is the last hope.
I wonder why they don't tell them that now in court.
Well, there is another case I've forgotten, just as another Supreme Court case. It says they have, these people are masters at using the words. Now let's see what it says. It says something to this effect. A lawyer asked for an appeal because the judge in the lower court did not tell them that they had the right to judge the law and the fact. The Supreme Court ruled in that case that the judge didn't have to tell them. And they use this old cliche, ignorance of the law is no excuse. He didn't say it's not still there, but he said you as the juror should know the law. Now that's always bothered me. You know, ignorance of the law is no excuse for you.
Or the judge.
Yeah.
Neither party can initiate ignorance, because
right.
it make the courts look like an imbecile.
Yeah.
And
That's amazing. You can go to prison, but ignorance of the law is no excuse for you. But your lawyer can misrepresent you and send you up for 40 years. And he spent 3 years in law school.
Yeah.
And nothing's done to him. So that's just some of the things that bothers me. Not bother me, it just bother all of us. Let's see if there's any other questions about the amendment process. I think, are we going to have Mr. Carter up? Is that the first one? After. Now, we're going to talk about the 11th. He's going to talk about the 11th, I think, and the 12th. Is that right? And the second first, right?
Yeah, the second will be our next subject that we're going to discuss.
All right, we're going to talk about the, Mr. Carter's going to come and talk about the second, and then we're going to go into the others. If everybody participates. So if you come up, Mr. Carter, we'll give you a chance to enlighten us on this second.
Okay.